We're taught from childhood that the legal system is built on logic, evidence, and undeniable facts. But there's a secret backdoor in the fortress of justice, and the password is simple. That's too weird to be a lie. What I'm about to show you will shatter everything you thought you knew about courtroom defense. We're diving into 50 real cases where lawyers didn't win with evidence or brilliant legal arguments. They won because their excuses were so absolutely insane, so mind-bendingly bizarre, that juries had no choice but to believe them. This isn't about loopholes. This is about the raw, unfiltered power of weaponized absurdity. Let's begin. Picture this. San Francisco, 1978. Former city supervisor Dan White doesn't just lose his temper, he plans. He sneaks through a window to bypass metal detectors, walks into City Hall, and executes Mayor George Moscone and Supervisor Harvey Milk in cold blood. This is premeditated murder, right? The death penalty seems inevitable. But his lawyers had a different story to tell. They painted a portrait of a man who'd completely unraveled, and their star witness wasn't a person, it was his diet. Dan White had abandoned his healthy lifestyle and was binging on Twinkies, Coca-Cola, and junk food. The media went crazy, calling it the Twinkie defense, but the real argument was far more calculated. They claimed the sugar wasn't the cause of his breakdown. It was a symptom of severe depression that had destroyed his mental capacity. The jury looked at this double execution and decided it was just manslaughter. The city exploded in riots, but Dan White walked out with a reduced sentence, all thanks to some cream-filled snack cakes. But food as a defense doesn't stop there. Fast forward to the United Kingdom, where a man commits a violent assault so brutal that witnesses are traumatized. His lawyer stands up in court and delivers one of the strangest defenses ever recorded: hypoglycemia. Not insanity, not self-defense, but dangerously low blood sugar triggered by binging on candy bars and soda. Medical experts testified that his brain was literally being starved of glucose, causing aggression, confusion, and a total loss of self-control. The judge agreed. The man was acquitted because a chocolate bar and a can of Coke apparently turned him into a temporary criminal. If you think that's insane, there's more. In another case, a woman was charged with assault after acting completely out of character. Her defense? Water intoxication. She'd been on an extreme health diet that required her to drink gallons of water every single day. And it induced a dangerous medical state called hyponatremia, where sodium levels plummet and the brain literally swells. She was in a state of delirium. Her lawyers argued, and the court agreed. She wasn't responsible. Her own obsession with health had turned her brain into a weapon against her. Now imagine waking up not in your bed, but in a police station. Your hands are covered in blood, an officer is staring at you, and you hear yourself say, "I think I killed some people." This is the nightmare that Kenneth Parks lived through in 1987. He had driven 14 miles to his in-law's home, murdered his mother-in-law, and nearly killed his father-in-law. The evidence was overwhelming. His fingerprints, the weapon, the blood, all of it pointed to him. But his defense was so audacious, it sounded like fiction. He was asleep the entire time. Not drunk, not on drugs, asleep. Sleep experts confirmed he had a severe parasomnia disorder with a documented history of sleepwalking. He had no motive, no memory, and no conscious control. The jury was forced to answer an impossible question. Can you convict someone who wasn't mentally present during the crime? Their answer was no. Kenneth Parks walked free. But sleepwalking isn't the only way your body can betray you. Let me introduce you to alien hand syndrome, a neurological disorder so bizarre it sounds like horror movie fiction. People suffering from this condition have a hand that operates completely independently. It unbuttons their shirts, grabs objects, even tries to choke them, and their conscious mind can do nothing to stop it. Now imagine being accused of shoplifting, and your defense is that your alien hand grabbed the merchandise and shoved it in your pocket while you watched in absolute horror. It's been used in court, and in some cases, it's actually worked. If your own brain isn't controlling your limb, how can you have criminal intent? The law simply doesn't know how to handle it. And then there's auto-brewery syndrome, possibly the most foolproof DUI defense ever conceived. Your body becomes a secret, illegal brewery. Yeast overgrowth in your gut ferments. Carbohydrates into ethanol. You can blow a 0.20 on a breathalyzer after eating nothing but pasta and bread. You swear to the officer you haven't had a drop to drink, and nobody believes you until doctors finally diagnose this incredibly rare condition. Multiple DUI charges have been completely dismissed because of it. Your own digestive system became the criminal. Let's talk about the ultimate identity crisis. Imagine being arrested for a serious crime, only to discover it wasn't you who did it. It was someone else who lives inside your head. This is the terrifying reality of dissociative identity disorder, once called multiple personality disorder. In the 1970s, Billy Milligan was charged with several violent crimes. His defense was that he had 24 distinct personalities living in his mind, and 2 of them were the real criminals. Billy himself, just an innocent bystander trapped in his own body. After extensive psychiatric evaluation, the court agreed and found him not guilty by reason of insanity. It was one of the first times this defense worked, and it opened a Pandora's box. But if you think multiple personalities are strange, what about being literally programmed like a human robot? In 1951, Denmark, a man walked into a bank, robbed it, and killed 2 people. His defense? He was under a hypnotic spell cast by his former cellmate, a puppet controlled by an evil mastermind. The court was so fascinated they had him hypnotized right there in front of the jury. The demonstration was so convincing that the hypnotist got life in prison, while the puppet got a drastically reduced sentence. And then there's the case that made the entire nation furious. Affluenza. In 2013, 16-year-old Ethan Couch got behind the wheel with a blood alcohol level 3 times the legal limit and killed 4 people. His lawyers brought in a psychologist who testified that Couch suffered from affluenza, a condition born of extreme wealth and privilege. He'd been so coddled by his rich parents that he was literally incapable of understanding that actions have consequences. The judge agreed and sentenced him to probation and rehab instead of prison. The public rage was unprecedented. Have you ever had a dream so vivid you weren't sure if it was real? Now imagine your body decided to act out that dream while your mind was still asleep. A man in Wales was found inside a stranger's home, apparently burglarizing it. His explanation sounded like pure desperation. He was having a nightmare about being in a video game and was acting it out physically. Medical experts confirmed he had a severe sleep disorder where the brain's off switch for the body during sleep doesn't function. His mind was offline, but his body was on autopilot. The jury believed him and acquitted him completely. But we're just getting started with altered realities. In Ohio, a woman named Tonda Ansley shot and killed her landlady. Her defense: she wasn't killing a person, she was freeing herself from the Matrix. She genuinely believed reality was a computer simulation, and her landlady was an agent keeping her trapped. The jury found her not guilty by reason of insanity, essentially agreeing that she was living in a completely different reality. And then there's the case that sounds like a medieval horror story, but happened in 1981 Connecticut. Arnie Johnson stabbed his landlord to death, and his lawyers used a defense never before attempted in an American courtroom: demonic possession. Ed and Lorraine Warren, the famous paranormal investigators, testified that Johnson had been possessed during an exorcism gone wrong. The judge rejected it as unprovable, but the sheer spectacle was so overwhelming that Johnson was only convicted of manslaughter, not murder. The devil might not have made him do it legally, but the argument worked well enough to save his life. Speaking of vampires and demons, a man in Texas was arrested for assault and claimed to be a 500-year-old vampire who needed human blood to survive. He wasn't joking. He maintained this belief throughout the entire trial. Psychiatric evaluation confirmed his profound delusion, and the jury found him not guilty by reason of insanity. Apparently, the legal system has no jurisdiction over the undead. What if your gender could be a legal defense? In the 1980s, a British woman named Sandy Craddock stabbed a co-worker to death. She had a long history of violent outbursts, and the evidence was damning. But her lawyers argued she wasn't a murderer. She was a victim of severe premenstrual syndrome. A doctor testified that her hormonal imbalance was like a boiling pan with the lid on. The court reduced her murder charge to manslaughter and gave her probation with mandatory hormone therapy. It was the first time PMS was successfully used as a legal defense, and it changed courtroom strategy forever. But biology gets even stranger. Stephen Mobley was convicted of murder in the 1990s, and during his death penalty appeal, his lawyers made a chilling argument. His DNA made him do it. They claimed Mobley carried a mutation in the MAOA gene, which has been linked to aggressive and impulsive behavior. He wasn't innocent, they argued, but he was a prisoner of his own genetic code, biologically predisposed to violence. While this specific appeal failed, it opened a terrifying debate. Where does free will end and biological destiny begin? And if that's not strange enough, there's the case of Charles Osborne, a man who holds the Guinness World Record for the longest continuous hiccup attack. 68 years from 1922 to 1990. In the 1930s, he was put on trial for murder based on a confession he allegedly gave to a friend. His lawyer's defense was brilliantly simple. A man who hiccups 40 times per minute is physically incapable of speaking a coherent sentence, let alone delivering a detailed murder confession. The jury found it medically implausible and acquitted him. Sometimes the best defense isn't about innocence. It's about breaking the system with pure logic. In medieval France, a coffin maker was sentenced to hang, but French law required executions to be carried out within 24 hours. When the executioner arrived, the coffin maker refused to go. Why? He hadn't built his own coffin yet, which was his legal right. Since he couldn't build it within the deadline, the execution couldn't legally proceed. Officials were so stumped by this logical paradox they had to let him go. Fast forward to 2002, and a 60-year-old mechanic in the UK receives a $25 parking fine. Instead of paying, he researches medieval law and discovers that trial by combat was never officially abolished. He formally challenges the licensing agency to a duel with samurai swords, Gurkha knives, or sledgehammers. The court adjourns in complete shock to figure out if this ancient right still exists. He ultimately won. Not by fighting, but because the system found it easier to drop the fine than deal with the legal paradox he'd created. And then there's the evil twin defense, possibly the most brilliant legal loophole in existence. The prosecution must prove beyond reasonable doubt that the defendant committed the crime. But what if the defendant has an identical twin? Eyewitnesses can't be certain. Forensic evidence matches both. DNA is identical. The entire system short-circuits. In multiple real cases, serious charges have been dropped simply because authorities couldn't definitively prove which twin was the culprit. It's the ultimate alibi, provided you were born with one. In the 1980s, a Hmong immigrant from Laos was charged with kidnapping and assault in the United States. His defense completely baffled the court. He was performing zijpojniam, a traditional form of courtship that involves ritually capturing a bride. To Western eyes, it looked like a violent abduction. To him, it was following the only cultural customs he'd ever known. His lawyers successfully argued he had no criminal intent, just a profound cultural misunderstanding. The court showed leniency, allowing a plea to a lesser charge with minimal sentencing. It's known as the cultural defense, and it forces the legal system to grapple with a difficult question. Can a crime in one culture be a tradition in another? Speaking of tradition, let's go back to 17th century France, where a woman was accused of witchcraft. The evidence? She'd been seen dancing with the devil at a witch's sabbath. Her lawyer came up with a defense of pure theological logic. For his client to have danced with the devil must exist. If the devil exists, he is a fallen angel, a spiritual being. And spiritual beings are incapable of the physical act of dancing. Therefore, the testimony is a physical impossibility. The court was so stumped by this reasoning they had no choice but to set her free. The devil, it turns out, had two left feet, and if medieval justice seems absurd, consider the benefit of clergy loophole that existed for centuries in England. If you were convicted of a capital crime, you could escape execution by proving you could read. The court would hand you a Bible open to Psalm 51:1, the neck verse. If you could read it aloud, you'd be branded on the thumb and set free instead of hanged. Countless illiterate criminals spent their time in jail desperately memorizing that single verse to save their lives. It was literally a life-or-death literacy test. Sometimes desperation breeds genius. A man in Italy was convicted of molestation and appealed on the grounds that he was too ugly to receive a fair trial. He argued that the all-female court was so repulsed by his appearance, they couldn't possibly be objective. The appellate court actually agreed, overturned the conviction, and ordered a retrial. Being ugly became a procedural disadvantage recognized by law. In another case of physical impossibility, a man in Washington was charged with indecent exposure. His defense was so stunningly bizarre, the courtroom fell silent. He argued his anatomy was so small, it couldn't possibly meet the legal definition of exposure. After what must have been the most awkward jury deliberation in history, they acquitted him. Then there's the case of a man weighing nearly 500 pounds who was sentenced to prison. His lawyer argued that imprisoning him would be a death sentence because his severe obesity and complex health needs were far beyond what the prison system could handle. The judge agreed that sending him to jail would constitute cruel and unusual punishment. He was literally too fat for prison and received house arrest instead. In 2012, a street mime in New York was arrested for aggressive panhandling. When brought in for questioning, he refused to speak. He didn't invoke his Fifth Amendment right. He simply continued his performance, miming being trapped in an invisible box throughout his entire arraignment. The judge eventually dropped the charges because it was impossible to conduct legal proceedings with a defendant who was, for all intents and purposes, a living, silent work of art. Can you kidnap someone who voluntarily climbs into your trunk? A Florida court had to answer this question when Michael Dickerson was caught after a police chase. An officer named John Jones popped Dickerson's trunk and climbed inside, thinking he could force the doors open from within. Dickerson hit the gas, leading to a second chase with an officer bouncing around in the trunk. When caught, one charge was kidnapping. The judge dismissed it with brilliant logic. You can't kidnap someone who kidnaps himself. A woman in the UK was charged with reckless driving after crashing into another vehicle. Her defense: a bee flew into her car and stung her, causing an involuntary panic reaction. Her lawyer argued this was automatism, a complete loss of conscious control. The judge agreed her response was a medical reflex, not reckless driving, and dismissed the charges. Similarly, a driver in Switzerland was caught on camera speeding. His defense was sneeze-induced acceleration. He claimed a violent sneezing fit caused his leg to spasm and press the accelerator. Medical experts testified this involuntary reflex was possible, and the court acquitted him. A sneeze beat a speeding ticket. In Wales, a man named Joel Lowe woke up and began brutally attacking the woman in his bed, believing she was a giant spider. His defense was hypnagogic hallucination, a terrifyingly vivid dream state that bleeds into waking reality. Sleep experts confirmed the condition was real. He wasn't attacking a person in his mind, he was fighting a monster. The court found him not guilty. We're reaching the peak of absurdity now. In 1995, MacArthur Wheeler robbed 2 banks in broad daylight without a mask. When shown security footage, he was genuinely shocked. Why? He'd covered his face in lemon juice, believing it would make him invisible to cameras like invisible ink. This wasn't insanity, just profound stupidity. His case became the foundation of the Dunning-Kruger effect. People too incompetent to recognize their own incompetence. A passionate Green Bay Packers fan was so devastated when the Minnesota Vikings won that he set his Vikings-loving neighbor's garage on fire. His defense? Extreme emotional disturbance caused by the loss. It wasn't arson. It was a temporary break from reality fueled by football. The jury convicted him of a significantly lesser charge, Sports rage became a legal excuse. In Oregon, police found a man swinging a plastic lightsaber at cars and shoppers. His explanation? He was a Jedi Knight practicing combat forms against Sith, hiding in plain sight. This wasn't a joke. His lawyer used this as the foundation for an insanity defense so complete he couldn't distinguish a parking lot from a Star Wars battlefield. He was found not guilty by reason of insanity. A woman in North Carolina watched her car burn, and insurance suspected arson. Her defense was arachnophobia. She testified that a large spider crawled inside her car while driving. In blind panic, she leaped out of the moving vehicle, which then rolled down a hill and caught fire. The jury found her terror so believable they acquitted her. A spider destroyed a car and got away with it. And finally, our grand finale. Stephen Wrights, a lawyer in Florida, was caught embezzling hundreds of thousands from clients. Representing himself, he argued he suffered from a shopping addiction, an uncontrollable pathological compulsion to buy luxury goods. He was the real victim, he claimed, a victim of his own exquisite taste. The sheer audacity of a lawyer using a self-diagnosed luxury addiction to excuse financial crimes is the perfect encapsulation of weaponized absurdity.